What's up, everybody? We're back at it today talking Brian Koberger. Some stuff's happening. There are some updates. There are some new documents filed. And we're going to look at a couple different things, one of which is very important and going to answer a lot of questions people had throughout the process when we were talking about whether or not Ann Taylor had a conflict as the public defender representing one of the victim's mothers. At the same time, the Koberger case comes in, and now she is lead counsel on that case. We'll talk about that. And I'm also going to talk a little bit more about how basically everything that either side wants sealed in this case, it seems like the judge will seal that document. So if you're still interested in this content, hit that like button. It's a tough topic. It's a brutal topic to see stuff like this happening, but I think it's an important process to follow and explain and get questions answered and discuss together in our little Lawyer You Know community. Speaking of that, check out the community page. We are going to post potential names for the chat, which I guess is a thing. So if you guys want to vote on that, get in the community page and vote for that so we can have that thing here for our community. So let's get to it. The first thing we're going to be looking at here is the motion to temporarily seal the stipulation to release property and related documents pending a hearing. Okay. Okay, good. So the titles are all showing up here. All right. State of Idaho, by and through the Latah County prosecuting attorney respectfully moves this court pursuant to Idaho Code of Administrative Rule 32G1 and Idaho Code 74-124 for a temporary order sealing the stipulation to release property and all related documents, including Exhibit A and B, and any order filed herein, because release or disclosure would interfere with enforcement proceedings, deprive a person of a right to a fair trial, constitute an unwarranted invasion of privacy, disclose the identity of a confidential source, which is always interesting when they throw that in there, regardless as to whether or not it's important or it's somebody we don't know or it's just law enforcement. Disclose investigative techniques and procedures, wherefore the state respectfully prays that the court temporarily seal from public disclosure herein under provisions of Idaho Code Administrative Rule 32G1 and this other Idaho ruling. And then that's the motion. Then, of course, we see here the order. Based on the motion to seal a stipulation to release property and all related documents filed herein, the court does hereby confirm and order that the stipulation to release, and I think it's supposed to be any and all related documents, including Exhibits A and B, and this order are confidential, exempt from disclosure, and are sealed pursuant to those Idaho rules. So no shocker there. Yes, it is going to be sealed. All right. So just more stuff getting sealed. We'll see what that is later. But we do have an order to redact and unseal a document that is the main course here for our video today, which is the judge's discussion with Ann Taylor and Brian Koberger about the decision to allow her to continue on as his attorney, whether or not there's a conflict, whether or not they've talked about it, what her involvement was in Xana Kernodle's case, mom's cases. So we'll get to all that and more now as we read this document together. So there is an order to unseal and redact. On January 27, 2023, this matter came before the court for a status hearing. The hearing was held via Zoom. Ashley Jennings appeared on behalf of the state of Idaho. Mr. Koberger appeared in custody with his attorney, Ann Taylor. Having weighed the interest in privacy and public disclosure, the court finds it prudent to unseal the records related to the status hearing on January 27, 2023 with redactions, including certain individuals' names, because the disclosures of this information might threaten or endanger the life or safety of said individual. So they're going to still redact some names. Therefore, after due consideration with good cause appearing. So it's hereby ordered that the records related to the status hearing on January 27, 2023 be redacted and unsealed. So they felt like there was a reason to seal these. I'm not really sure. Maybe it was public. Maybe they're going to try to slow play stuff so that the public has questions. They don't get them answered immediately. So when it comes out, a month or two later, people stop caring and stop talking about it. I don't know. But there was so much talk about this conflict and Ann Taylor and how she could do this and how it was wrong. And we talked a lot about what it could have been, what her involvement could have been with Kernodle, how she is the public defender. So it's a little bit different than other public defenders. Well, we get some answers here. The court noted the presence of counsel and the defendant and stated that the defendant is still in custody, the court noted that all parties were appearing via Zoom. Court stated that this is the time set for the status conference. Court stated that, and these are like notes. This is like the minutes. So this is what happened. It's not a verbatim transcript. Court stated that this is a sealed recording of the proceeding and the minutes will be saved in the court file. Court stated that the purpose of this hearing is to ensure defendant is fully advised of his right to counsel and any potential conflict Ms. Taylor may have. So they had a specific hearing. People were talking about this. Are they explaining this to him? How does he know? Is this fair? Should she have this? Some people were mad that he got Ann Taylor. He thought, oh, she's conflicted off. He's got to go with some other lawyer that maybe is not as good. Well, the court takes that seriously. They take the right to counsel seriously. They take conflicts seriously. The lawyers take it seriously. We will hear what the lawyers did in this case. So this is taken seriously. A question all of you had is a very legitimate question that everybody had to get answered in this case, and we got it answered appropriately. So I think that's really important. You guys have your finger on the pulse. Just because you're not lawyers, just because you're not involved in the process, doesn't mean you don't know what's going on or your common sense doesn't raise red flags. All right, where was I here? Okay, the court further stated that the court recently met with Ms. Jennings and Ms. Taylor, and it was determined that it would be prudent to have this hearing. The court stated that Ms. Taylor, I think the media attention on this conflict could have also had something to do with this. The court stated that Ms. Taylor is the appointed public defender for Kootenai County. I know somebody's already told me how to pronounce that, but with all the Murdoch and Murals and Alec and Ellick, I've kind of lost my Kootenai pronunciation. And that Ms. Taylor's name is on nearly all letterhead for the Kootenai County Public Defender's Office, whether she is acting attorney or not. And that's important. And that's something we said. That's what makes it different because she is the public defender. So her name is going to be on all sorts of documents, even on cases she's not specifically working on or has no specific knowledge about. The court explained to the defendant, this is the judge talking to Kohberger, that a conflict of interest can arise if counsel currently or previously represents an individual or if there is some other conflict such that they would need to withdraw. The court stated that this court generally leaves the issue of conflict and the decision of if it's necessary to withdraw to each attorney on a case-by-case basis. The judge doesn't make the call unless they have to. That's the point. And later, if the defendant files a motion for, that he had ineffective assistance of counsel because there was a conflict that he didn't know about, then the judge will be forced to make a decision there. But usually the judge doesn't step in at this point. Leaves that decision to the attorneys and to allow counsel time to discuss the decision with the individual they are representing. The court stated that based upon the discussion with counsel this morning, it is the court's understanding that the defendant is in agreement with Ms. Taylor's continuing to represent him, and further stated that it is the court's understanding that Ms. Taylor does not believe there is a conflict. The defendant stated that this is correct. So there's a couple things in here that are important. When we talked about conflict and whether or not she can continue on, a lot of times that is the decision of the person she continues to represent, which would be Bryan Kohberger. He can waive that conflict. He can agree that there is no conflict, and that pretty much makes it a moot point. Part of that seems to have happened here. However, the next line that Ms. Taylor does not believe there is a conflict leads me to believe that in her conversations with Bryan Kohberger, she didn't actually get him to waive a conflict of interest, but instead she told him there was no conflict and he agreed. That's interesting. Because it says he stated it's correct that there is no conflict, not that there is a conflict that he is waiving. I probably would have said, if I didn't think there was a conflict, I don't think there's a conflict, but if there is, based on this information, Kohberger is going to sign a conflict waiver as well, just to protect yourself. All right. Ms. Taylor stated her name appears on every document in the public defender's office. Below her name is the individual who actually represents the named individual in the case. This is not a surprise to anybody in the courtroom, but for the record, she puts it on the record. Ms. Taylor stated that the specific issue with the media has brought attention. Hold on, let me read that again. But it is specifically the media, I guess. Obviously, I haven't read this whole thing. I just read the title and knew what the gist of it was. So this is interesting. She does actually mention the media as she's making her statement in court. Stated that the specific issue with the media has brought attention to are two cases involving Xana Kernodle's mother, Miss Kernodle. Ms. Taylor stated that there was an open felony case that she was not assigned to, and the case has since been conflicted out. So it seems like there's some kind of conflict if you had to conflict it out of the public defender's office, which happens all the time. But she, Ms. Taylor, was not specifically assigned to that case. Now, it's interesting if you remember back to when we discussed the interview with Kernodle's mother and how she's the only person she trusted. This is the person handling her case. Ms. Taylor's like, I wasn't even individually assigned to this case. Maybe she helped her in the past and maybe she was referencing a past case, but just because Ann Taylor's name is on something does not mean she's the lawyer actually working it. Ms. Taylor further stated that there was a 2017 misdemeanor case which was sentenced and her office was waiting to withdraw from. Okay, so there was an earlier case. Doesn't really say that she was specifically, so she wasn't even the public defender on that case. Ms. Taylor stated that the public defender who represented Ms. Kernodle in that matter was blank, and they probably redacted her name because they don't want the media coming after him or her. Who left the PD's office in September or October. So that's even worse, right? They're not even at the PD's office. We don't want them getting hammered by questions or people bothering them. So that's an appropriate redaction. But the rest of this seems like it should have come out from the jump, in my opinion. Ms. Taylor stated that her practice is to transfer all cases that are pending withdrawal or have a bench warrant issued to her. Ms. Taylor stated that the 2017 case was assigned to her on October 20th. And from October 20th until the date she withdrew, Ms. Taylor stated that she had no contact or relationship with Ms. Kernodle and has not met her or provided any legal advice to her. Now listen, somebody's telling the truth, somebody's not, somebody's exaggerating, somebody's not. This is a lawyer under oath in front of a judge on the record saying, I've never met her, I've never provided her any legal advice. Ms. Taylor stated that most of what the media is reporting on regarding the Kootenai County cases is untrue. Shocker. Not like we've never seen that before, right? The media running with something, trying to make a story where there's nothing, especially in a situation like this where we talked about how it's probably very unlikely that there is a conflict. Just because her name is on something as the public defender doesn't mean that she's actually representing her. Just because the client says there's, I should say, news articles and titles that the only person she trusted is now turned on her doesn't make it true. Ms. Taylor stated that she has spoken with Bill Thompson and Ashley Jennings, which are the prosecutors, and explained the above situation to them. Ms. Taylor stated that she has spoken with blank at the ISB Bar Counsel's office, which is a great indication that she is covering her track. I shouldn't say covering her track. She's doing her due diligence, calling the bar office in the Idaho State Bar to make sure everything she's doing is ethical, that there's no conflicts, that there are no issues. That's the best way to cover yourself in case somebody comes back and says you did it on purpose or didn't know or should have known. And you're like, I checked with the bar and everything I did was ethical. She conferred with blank and blank. They usually give you names of lawyers that you spoke to and gave you an advisory opinion. And all three do not believe that there is a conflict so long as the defendant is comfortable with her remaining on his counsel. Again, it's the defendant's choice. And he, obviously, if you get the public defender, death penalty certified, good reputation, I would understand if he wanted to waive conflicts in this case. Ms. Taylor stated that there is no other person that she is connected to in this case and stated that Mr. Kohberger is the only individual in this case to whom she owes a duty of advocacy and loyalty. All of this fits right in line with how it's supposed to go and kind of what I expected in this case. Not to say I couldn't have been wrong. I absolutely could have been wrong and the lawyer could have done something shady. We just finished a 6-week trial of a lawyer doing something shady. It just would have surprised me, and this is more along the lines of what I expected in this situation. Upon inquiry from the court, Ms. Jennings stated that this is her understanding as well. The court questioned the defendant. The defendant stated that given the information he has heard and the conversations he has had with Ms. Taylor, he feels comfortable proceeding with her as his counsel. The court advised the defendant of his right to have an attorney, and if he believes there is a conflict, the court can find and appoint different counsel. The defendant stated that he understood. The court questioned the defendant. The defendant stated that it is his wish to proceed with Ms. Taylor as counsel to make sure there is no confusion, no misunderstanding. This is Kohberger's choice. This is what Kohberger wants, and Taylor as his lawyer, and that is what's going to happen here in this case. The court stated that there is a lot of speculation surrounding this case and has spoken with the attorneys regarding staying focused on the facts. The court appreciates this issue being brought to the court's attention and stated that this information appropriately covers any concerns. Very interesting. To me, that's huge. And I wish this would have been around when we were initially discussing the conflict issue and when rumors were kind of running wild, because this puts all that to bed. They don't think there is a conflict. Kohberger agrees. Kohberger wants her as his lawyer. She has never given legal advice to Kernodle's mother. She is the acting or sitting elected public defender. Her name is on everything. That does not mean she's actively working on these cases. Here's the lawyer who actually handled that case. I called the bar counsel for some opinion, making sure everything I did was ethical. Here's where we are. And then the judge has a colloquy, a discussion, a question and answer session with Bryan Kohberger himself to make sure this is all okay. Boom. And it's much ado about nothing. And this is why, in a situation, I think sealing this document for a month and a half actually made matters worse, because less people are even going to, they're on to the next thing, right? We've had an entire Murdoch trial since this happened, right? So I think this actually made it worse and made speculation more rampant than if we would have just had this come out and been unsealed when it happened to answer a lot of the questions that we had. Very quickly, I'm going to go through two other quick motions. I think this is the first one. Motion to appoint co-counsel. So Ann Taylor comes now. Ann Taylor, the Kootenai County Public Defender and attorney in the above named defendant, moves this court to appoint an additional death qualified co-counsel in the above entitled matter. This motion is made pursuant to the 5th, 6th, 8th, and 14th Amendments to the Idaho and United States Constitution, Rule 44.3 of the Idaho Criminal Rules, and the ABA guidelines for appointment and performance of counsel in death penalty cases. That was just filed earlier this month. And then we have the court's order here. The order appointing co-counsel. The court having before it the defendant's motion to appoint co-counsel and good cause appearing. Now, therefore, it is hereby ordered that an additional death qualified co-counsel shall be appointed in the above entitled matter just a couple days ago. So Kohberger will get his second death penalty qualified attorney to handle this case with Ann Taylor as co-counsel. That has nothing to do with the conflict of interest. That has to do with the fact that it's a death penalty case, two death penalty lawyers on a death penalty case here in Idaho. No surprises there. Let me know what you think of this video. Let me know any questions you have in the comments, specifically with the conflict of interest. Are you surprised? Is this what you expected? Do you think there's still an issue? Do you think she shouldn't represent Bryan Kohberger? And let me know why, because these arguments and these discussions are still good for public policy reasons as to why you think that there is still an issue, why you think she shouldn't be able to represent him, or if you think it's totally appropriate, everything was done above board, and we're glad to see this now under oath, sworn statements, answering a lot of the questions that the public had about, is this fair? Is there a conflict? What does Taylor say? What does Kohberger say? We got those answers today. So hopefully you guys enjoyed this video. Appreciate you joining. Hit the like button on the way out and subscribe if you haven't already.